One of the issues most often at stake in defamation cases before the European Court is the distinction which needs to be made between factual allegations on the one hand, such as an accusation of theft, and statements of opinion on the other, for example, that a particular chef is a bad cook. The European Court of Human Rights has a long-established doctrine that distinguishes between facts and value judgments. It is said that a very careful distinction needs to be made between facts and value judgments. The existence of facts can be demonstrated, whereas the truth of a value judgment is not susceptible of proof. As regards value judgments, a requirement to prove their truth is impossible of fulfillment, and it infringes freedom of opinion in itself. This is from the seminal case of Lingens v. Austria. And this was further elaborated in the Torgerson case, which I mentioned earlier. Torgerson had not himself documented instances of police brutality, but he commented on other accounts of police violence. And even though some of the evidence on which Torgerson had based his argument proved to be incorrect, some of it was also true. The facts, in addition, that this was a matter of considerable public concern meant that the burden of establishing a connection between his value judgment and the underlying facts was light. Now, satire is a particular form of opinion. It typically comments on issues of public concern, often politics, and individual politicians in particular, and tends to do so in a way that is funny, but which the person at the receiving end typically experiences as quite insulting. The European Court has consistently allowed great latitude for humorous and satirical comment. And this general latitude for humour and satire also applies to other creative writing. In two Turkish cases, the cases of Karatas and Alinak, the court found that the material that might in other circumstances be legitimately restricted, for example because it seemed to incite violence, were to be permitted because of their artistic context. In the case of Karatas, it was poetry. Similarly, in a 2007 case involving an alleged attack on reputation, the European Court was very tolerant of artistic creation. It held that the court finds that such portrayal amounted to a caricature of the persons concerned using satirical elements. It notes that satire is a form of artistic expression and social commentary and, by its inherent features of exaggeration and distortion of reality, naturally aims to provoke and agitate. Accordingly, any interferences with an artist's right to such expression must be examined with particular care. This is from the court's judgment in Vereinigung Bildende Künstler v. Austria. This latitude is not limitless, however. In the case of Linden v. France, the court found a novel featuring a fictionalized version of the far-right leader Jean-Marie Le Pen to be defamatory. Although this particular 2007 judgment of the Grand Chamber provoked a fiercely reasoned dissenting judgment which accused a majority of the court of departing from its previously established jurisprudence.